Good evening, everyone. This is Moshe Frank from Frank News, streaming live from the Levi Art Gallery. Tonight, we have a very special guest, Mr. Levi Heubner, ESQ, an attorney here in New York City. And today, a ruling came out about 770 Eastern Parkway. And Levi, Mr. Heubner, has been following the case for a very long time. And there's a 144-page ruling. And most simple people can't read through or definitely don't understand what's going on. So we said, let's bring down the big gun to translate exactly what it means. How are you, Mr. Heubner?
I'm fine, thank you. So
now just a little, if we take a few steps back, I know there are many cases about who runs 770 for the past, I guess, 20 or 30 years has been in court. Did anything change drastically from today's ruling, or is it just another push off?
That's a good question. So before today, you're not going to get a deep analysis of the decision from me. I still have to continue reading it again and analyzing it to give a deep analysis. Today, I can talk a little bit generally about the history and what's going on and what kind of position this decision is going to put the litigants in. When I say the litigants, I mean all the parties that are affected by the litigation directly because they are parties to the litigation, and additionally to the community and how it will affect the community, and practically speaking. So you have to understand that there was two Supreme Court decisions which both resulted in appeals, which had modifications on the appeals that never really reached a conclusion into the case. And this decision by Judge Harriet Thompson, who I happen to know, is a very fine judge. She's an interesting person. She has herself an interesting background. I think that's a little bit reflected in her decision. She really tried the best that she could under the circumstances, considering that it's also a trial, to be respectful to the parties and respectful to the history of Lubavitch and respectful to the status of the Rebbe. And she herself is a religious woman, Christian woman, very considerate, and she has a lot of respect for religious institutions. And I know that for a fact, myself having practiced in front of her. And she's very sensitive to these kind of cases, the outcome and how it's going to affect communities and people. You also have to take into effect the perspective that when she was sitting in this case, she happens now to have been transferred practically a year ago to the surrogate's court, where she's a sitting surrogate in Brooklyn, Kings County, in the Supreme Court, so to speak. Before that, she was a judge in the landlord-tenant court. I happen to know her before she's a judge. She's an extremely talented litigator. She's a lawyer's judge. She's considerate of the parties that come before her, and she really tries to delve into the case while being respectful to all those involved.
So in practicality,
it's not so simple, because in the substance of the decision, which is part of her decision, is not so surprising. She said in sum and substance that the chief litigants, that Shem Tov and Krinsky, who initially brought this action as the petitioners, had, on behalf of Americas, had the possessory rights to the corporations that hold the synagogue. And that's not really so surprising, because almost nobody is denying that. the real question, which are going to be raised in all the appeals, are all the issues surrounding that regarding constructive trust and community interests. But practically speaking, and I'm just asking that question, is, and I'd ask that hypothetically, I mean, practically speaking, what's going to be now? What's going to change in 770 now? That's a question for the community. What's going to change now?
So the ruling say basically there's like a volume and then there's Americas, right?
So they're saying that she's saying in some substance that the Gaboim who are in the synagogue now don't have control of the entity that owns the synagogue. And theoretically, the entity that owns the synagogue is the entity that's going to have control. So, I mean, what is it? Are you telling me that Shem Tov and Krinsky and Sharfstein are going to come in and be the Gaboim of 770 and they're going to run 770? Are they going to put in Gaboim of 770 that the community hasn't elected and don't recognize? I'm just asking. Or are they going to put in Gaboim that the community do recognize? So I can't give you that answer. These are all thoughts.
So the ruling is in favor of Americas, correct?
What the ruling is saying is that the organization, that corporation that holds the ownership of the actual premises is the one who has the control of the premises.
Now,
what does that mean? Practically speaking, I don't know, but there's another problem with the decision, and the problem with the decision is that just in the last paragraph of the decision, it says that the decision, that there's a 6-month stay of the decision, that from an entry of judgment and service upon the parties, it's going to become effective, but it can't, according to the governor's orders, while the COVID-19 crisis is going on, it can't be, an order with notice of entry can't be filed and cannot be enforced. There's a question when the 6 months will start. And so practically before anything can be even, before I see anybody even be able to do legal action to actually try to enforce anything in this decision is probably going to take, just to start, is going to take nearly, practically speaking, close to a year. In the interim, once the courts are opened back up, there's going to be appeals filed and there's going to be stays filed. I'm just talking from a legal perspective now.
Right.
And everybody could change, the status quo could change. And then once that's done, this is a kind of litigation that could go on again for a long period of time. What I'm looking at, and the real question I'd ask is,
were you ever involved in the case legally or just as an outsider viewing it?
I was never involved in the case that was before Judge Harriet Thompson.
Earlier parts?
I was involved in, I was never involved in that case. What I was involved in, thank God, resolving 2 Supreme Court cases, 1 federal case, and 2 appellate division cases that the Rabbanim were involved in. And thank God we came to a settlement with 1 Beis Din. And that's where it, I think, brings in an interesting question. While I was very near settling that case, and the case was almost settled, the prior attorneys in that case who I took over from, who backed out of the case, Abrams and Wintner, called me up on the phone to have a telephone conference with me. And since I respect them as attorneys, and I was happy to have a telephone conference with them, and we had a long talk about the settlement. And I told them what's going on and how the case is settled and how the parties are looking at it and how they want to settle the case and all their differences. So Mr. Abramson asked me a question. It's Wintner's partner. He's a senior partner in the firm. Heubner is the senior attorney in the firm. And Mr. Abramson asked me, he said, Mr. Heubner, I want to ask you a question. What happens, and this was before the settlement was completely finalized, if there's a sitting Bezdin with Rabbi Shway and Rabbi Broin and Rabbi Azava, and that Bezdin sends a letter to the litigants in the 770 case and tells them to cease the litigation. So I said to him, I'm not a halachic authority. Seems like you'll have to ask the rabbis that question. But since you're asking the question, I asked Mr. Abramson and Mr. Wintner, who do you represent in the 770 case? They said, well, we represent Rabbi Shem Tov and Rabbi Krinsky. I said, okay. And so what they were asking was, if the Bezdin got involved, they asked then if the Bezdin got involved and said cease the 770 litigation. So now my question is, since 770 is in Crown Heights and the Bezdin, the Badatz of Crown Heights, has the sole halachic authority of Crown Heights, my question is, what happens if the Bezdin issues an ikul, a stay, and say that they want a stay of all enforcement of the litigation and they want the status quo to remain untouched until the parties go to Din Torah? They're asked that question. Now I'm asking that question.
All right, so you're assuming that the parties will agree to listen to the Bezdin and go to court, right?
Say that again.
You're assuming that the parties in this case would agree to go to secular court.
Secular court?
Yeah, regular court, whatever you call it. You're assuming that they would listen to the Bezdin and follow through, or you're saying legally maybe the Bezdin has the power to actually be effective in
why? I don't see why any party why would not, and it's one united Bezdin now. Why would not any party want to listen to one united Bezdin? That's a Bezdin of Crown Heights that's been doing a great job of leading us through the COVID crisis. I don't know, I can't imagine that there would be anybody in Crown Heights that wouldn't want to listen to the united Bezdin of Crown Heights. That's a Bezdin for all of Crown Heights. Could you imagine such a thing?
I think you definitely accomplished great things working on a settlement with Rabbanim, and I definitely commend you for that. Now, is this case, just technically speaking, this case could be appealed a million times as it has done in the past? Is there a limit, or how does these cases work legally?
So in this case, there's a couple of situations here that I'm not doing a complete analytical analysis of the whole case, but just to give you al regel achas, standing on one leg, that you have to understand that part of this case is based on 2 Supreme Court decisions, 2 appellate court decisions. Now, this actual decision itself, either party could have questions with certain rulings of this decision, and either party has the right to appeal any part of this decision to the appellate term, it's called, because it's coming from civil court. And if any party is not happy with the response or the decision of the appellate term, either party has the opportunity and the right to appeal that decision to the appellate division of the state of New York in the Second Department. And then if anybody doesn't, you ask me the question, let me finish. And if anybody is not satisfied with that decision, they have the right to go to the Court of Appeals and appeal that decision to the Court of Appeals, depending on the various and the responses from the judges that they get in the appellate division. So the real thing, I think the real goal here would be, and I think that's what everybody really wants. I think that's what Rabbi Shem Tov wants, or Rabbi Krinsky wants, and the Gaboyim want. I think the real goal here is that I think what everybody would really be happy with, just like they were calling for in the International Shluchim Convention, was that all the parties in this time would get together and they would unite in a resolution that would come through peace, and a resolution that would come through negotiation, that everybody could be satisfied and happy. And I really think that that's the real goal that should be looked at, and not appeals and arguments. And I think really there's no reason why there couldn't now at this time be reached a compromise by all parties to a solution that would make everybody happy.
In an ideal world, right?
I think we live in an ideal world. I think now, in this time, with what's going on, I think that everybody realizes that the real, as Lubavitchers, that the real goal to be Achdus, the real goal to bring Mashiach, and the real goal for this community is that as a community that all Lubavitchers are one, and we should not only be unified as one and act as one, but we should also get together and make sure that we're acting as one for the whole community.
How much money do you estimate was spent on this case by both parties so far?
Too much money.
Millions?
$1 million is conservative. I have no idea how much money was spent, but I would definitely say that $1 million is conservative, extremely conservative.
And who's funding both sides? You know, the people backing each one?
I have no idea.
No idea. When you worked in a case, was pro bono or you're getting paid?
It's something that I can't discuss. It's attorney-client privilege information.
No problem. Last thing, why does it seem like criminal cases go through much quicker and these civil cases seem to go on and on, or I'm just imagining that?
You're imagining.
You're saying a criminal case could go on for 30 years also, and the guy won't end up in jail?
Where did you get 30 years from?
I'm saying, but this 770 case is going on from 1994, right?
The 770 case is not 30 years.
20 years?
Okay, it's not one case. You got to remember, this is the third case. There was 2 Supreme Court cases. This is a civil court case in the housing court. It's a different aspect. And
so 3 totally separate cases with
3 totally separate cases that have underlying tangential issues that on some occasions interlock.
Interesting. So it's not, so even though it looks like one big long case, it's 3 separate cases and each one has its own appeals and back and forth for each thing. Correct. So even, okay, now I thank you for clarifying that. For me, it's just one big blur. That I obviously am not involved in this case. I'm not a lawyer or a community actor or anything like that. I'm just a curious outsider. I'm trying to understand a little bit better what's going on. So this ruling today seems like a win for Americans, but based on the history, if you might take away, tell me if I'm wrong, that appeals go after appeals and do different cases, and as long as there's funding on both sides, this case could go on for another 20, 30 years.
I think what I want to say is I think that what it did is all it did was it elucidated America's possessory rights, but it really didn't resolve all the issues of the case. And again, practically speaking, I really don't. I'm just saying, practically speaking, I just see more litigation going on. And what really would be nice was instead of more litigation going on and wasting more time and money and prolonging, so to speak, the agony, if all the sides would get together and if all the really, I don't want to say sides, if all the interested parties would get together, like the call of all the shluchim, like Rabbi Lazar said, like Rabbi Kotlarsky, like the many different speakers that spoke in all the many multiple forebringings we've had in the last couple of days, that we should all get together as Lubavitchers and try to figure this out, because this is not just a case affecting a balabus with his building, and it's his choice who's there. It's regardless of whatever's going to happen, it's going to be the same mispalim. It's going to be the residents of Crown Heights are going to be the same mispalim of 770 as always has been.
So I think what people are sarcastic about is that the for the benefit of the people in the case is better for them to settle, but it's probably better for the lawyers to keep the case going, right, Mr. Heubner?
Are you saying that the lawyers might have a financial interest in keeping the case going?
I'm assuming in any case the lawyers are very happy to run that meter. So every time they lose it, oh, we have another option. Let's do this. Let's do that. They keep on dancing around looking for ways to get more billable hours. I mean, that would seem to make sense.
That's a great question that you're asking. When I settled, when I was in the midst of settling, I apologize, when I was in the midst of working with all the parties, and I was just facilitating their agreement to settle the Badats and the trademark case, and that ended up, the settlement expanded to all litigation and all controversies that the Beis Din had. And when Wintner and Abramson asked me the question that they had asked me earlier, I said to them, if you represent Shem Krinsky, and now you're taking a position on the settlement in this case, and you're asking me what happens if the Rabbanim send out a letter to stop the 770 litigation, it sounds like you have a little bit of a conflict of interest because you have a vested interest. Because if that litigation is going to stop, you're not going to continue to get paid. And they sort of hemmed and hawed. And then we ended up getting to court on that a few days later on a Friday, and Judge Rowan Mann was handling a case, and she said that your question just seems to show that there's third parties are trying to interfere in this settlement, third parties with a vested interest. And I'm telling you, what you're going to do in another courtroom, I can't control, but you're not going to come into my courtroom and try to sabotage a settlement. So yeah, I think that there's lawyers who could make a lot of money from continued litigation, and I think I'll tell all my clients that the settling a case is going to be much less expensive and a lot more productive. Just like in the Rabbanim's case, I would have made a lot of money if that case would have gone to trial, because I get paid a lot of money for going to trial. And it definitely was not in my financial interest for that case to settle. But I pushed with all my might and all my soul to settle that case, because not only that it was the right thing to do, but as always, I try to do what's right for my clients.
So takeaway for me is that the case implies that Mercus controls 770 and they can only execute that within 6 months. In this case with COVID-19, we'll know when the 6 months actually starts. In addition to that, it could be appealed like it has been appealed a million times. A new case can be pulled up. So in summary, it potentially can mean meaningless or meaningful.
What I was saying before, not only that appeals and not only that the time that it will take, but practicality speaking. So, the only really way they're going to control 770 with this decision is if they close it down and turn it into a bus stop for the Jewish Children's Museum. Otherwise, I really don't know how anybody's going to change 770.
But you're saying it's likely they're going to appeal it anyway, so. Do they
Both
have
sides could appeal. I don't say it's likely. I'm saying they have the right and have the very strong possibility that could happen.
Could America's close the door right? Do they have the legal rights to shut the door right now, or they have to wait 6 months until whatever the judge said?
The judgment is not even enforceable now. It's not enforceable until 6 months at the closest, until 6 months after the COVID crisis ends. Because right now, there's no court action. There's a stay from the governor. There's no evictions. There's no court actions. And all cases, and basically all state cases are stayed.
So, based on your past success with making a settlement or a long fight with Rabbanim Baruch Hashem that got together with your creative assistants, you would recommend them settling the case because this go on and on and on. And unless there are two people who have unlimited funds and time, then they should probably be better off settling the case, right, Mr. Heubner? For the sake of peace.
In a nutshell, yes, 100%.
Do you see that as a likely option here, or is it much more? It's probably more difficult. I mean, I don't know. Who knows what's more difficult, that you got the Rabbanim to get together and getting Americans like those people with Gabbayim together. I don't know which is easier or harder. But
one of the things before I took on the Rabbanim's case, I was learning with Yaska Levin from the Frierdiker Rebbe Pasach Eliyahu, and it's basically you can change reality, you can make reality, and the way I see it, I think that settling this case would be much easier than continuing the litigation. It most definitively would be much more cost effective. And for the good of the community, and for the achdus of the community, and for the happiness of everybody, I think that everybody would be. I think you see that everybody was so happy when the Rabbanim, all the difficulties and differences with the Rabbanim were settled, and everybody was extremely pleased and happy with that. And I think that the same thing here, that if everybody would see that this case was settled, I think that the whole community would just have a big sigh of relief and be extremely happy. And it's a community. We're all one Lubavitch, and we all Lubavitchers like to daven in 770. And I think there would be just so much more pleasurable.
To end off, Mr. Heubner, what is your law specialty that people could reach out to you for? Do you specialize in anything specific?
Complex litigation.
What does that mean in layman's term?
Complicated cases.
Complicated cases. In any area?
In not any area, but a lot of areas.
And how many years have you been practicing law for?
I finished law school in 1996.
Wow, so 25 years, right?
Something like that.
Very impressive. Okay. Mr. Heubner, thank you.
Thank you very much. Thank you for your wonderful time. You give a lot of interviews. They're very enjoyable. And you should always have hatzlacha. And thank you for your good work for the community also.
I appreciate it. It's just interesting. The stickier the cases, the harder it is to find people who are brave enough to get on camera to talk to people and to give people the real clear picture on the matter. So I really appreciate it from an interviewer perspective for coming on tonight and giving people a full picture, understanding the complexities of it, the likelihood of settling, and the likelihood of it's going to be reappealed, and therefore, based on all this information, definitely settling and making some type of agreement, peace deal, is the betterment of everyone. And
thank you.
You clearly have success with Rabban doing that, and perhaps we get you involved in this great matter. Thank you so much.
Thank you so much.
This is Moshe Frank from Frank News at the Levine Art Gallery with Mr. Heubner, ESQ. Is that the right title? ESQ?
Just Levi Heubner is fine.
Thank you. All the best.
Bye-bye.